Hi, welcome back. This week I'm in the Botanic Gardens, just at the forecourt of the Opera House. Today's topic moves on from examination in chief to cross-examination. Cross-examination is the testing and challenging of a witness's evidence by the other side. It can last from a few minutes to a few hours to 3, 4, 5 days. It has no equivalent in the civil law system, and I find most foreign witnesses underestimate its rigours. It can be harrowing and emotionally exhausting if you find yourself in the witness box for a long time. I have seen a witness leave the witness box and refuse to come back after a break, which is great if it's the other side's witness, but not so great when it's yours. The purpose of cross-examination is twofold. First, it is to test the witness's evidence by subjecting it to intense scrutiny. And second, it is to give the witness an opportunity to respond to any contradictory versions of events. This is called the rule in Brown and Dunn. Brown and Dunn was an old English case which established this principle as a matter of fairness to the witness. A witness's evidence is scrutinised by looking for inaccuracies, inconsistencies, and admissions which put into doubt the witness's version of events. Legal teams and people like me spend days and sometimes weeks trawling through affidavits and documents looking for ways to challenge a witness's evidence. Done well, cross-examination can be extremely effective and can really undermine the other party's case. This is especially the case if a witness is unprepared or untruthful. Whilst the main purpose of cross-examination is to test the evidence, the aim is to get the judge, or a jury if there is one, to prefer your client's version of events. Most of you will have seen cross-examination on American TV shows. Suits, Law and Order, if you're my generation, LA Law. There's no shouting or accusations, no speeches. There's no barrage of questions climaxing in the witness capitulating. None of these are permissible under Australian rules of evidence. For example, a witness can only be asked one question at a time, and they must be given time to answer the question. Most witnesses are spoken to courteously, and the judge will always permit them to finish their answer. It is simply the relentless, detailed questioning that brings to light inconsistencies and inaccuracies and creates an overall impression of the truthfulness, reliability, or evasiveness of the witness. Cross-examination is a very disempowering experience. All the power is held by the cross-examiner, under the watchfulness of the judge, of course, but most judges won't intervene. A witness does not know the questions in advance. They do not know how long the cross-examination is going to go for, whether the next question is the last question, or whether there's another 5 hours to go. And they are not allowed to talk to anybody whilst under cross-examination about the case, particularly not their lawyers or other witnesses. This is the case even where the cross-examination lasts days. A witness is required to answer every question that is relevant and admissible that is put to them, even if they don't want to, and even if the question is very uncomfortable. They are required to remain in the witness box, answering questions until they are excused by the judge. The questions in cross-examination are designed to be able to be answered yes or no only. This is so that the cross-examiner retains control of the answers. An experienced cross-examiner will not ask a question he or she does not already know the answer to. So you can see a witness has no power. It is an uncomfortable experience for most people. Some personalities cope better than others, but regardless of personality, it's really important to prepare your witnesses well. It can make a big difference to how they perform in the witness box.